Former President Jacob Zuma is asking the Pietermaritzburg High Court to grant him a permanent stay of prosecution. He is facing corruption, fraud, money laundering and racketeering charges. His legal team argues the case has dragged way too long and the charges are a clear case of political-inspired legal acts. To discuss this, we're joined by David Lewis from Corruption Watch. He's joining us via Skype. Good evening, David. And in studio, I have criminal law expert Ulrich. Very good evening. Let's start with you and just get a bit of admin out the way, because at the beginning of proceedings today, Advocate Sikakane was complaining that he's not allowed to argue the case in isiZulu.
Yes, indeed. There was a Constitutional Court judgment handed down last year which confirmed that the official language to be used in South African courts going forward would be English, and that pleadings could no longer be in a different language. We still, saw and experienced arguing in Afrikaans in the Pretoria High Court, for instance.
Yeah.
But that has now been set aside purely because of the logistical nightmare surrounding it. We have 11 official languages in this country,
yeah.
And if everyone had to argue in their own specific language, then it would mean it would cause a nightmare for the court managers to arrange interpreters, and it would just prolong proceedings with so much more.
Yep.
It was not a personal attack on the advocate. It is purely the court abiding by the Constitutional Court judgment handed down last year, and you must argue in English now in today's courts.
Let's talk about the matter at hand. What are the chances that the court will grant Mr. Zuma the permanent stay?
Well, I think that's the million-dollar question, obviously, that everyone is asking. You have to look at the history of this matter. It relates to incidents which occurred as far back as 1999. We all know that Schabir Shaik was convicted in 2005 on similar charges to this. In fact, Jacob Zuma's advocate today referred to that, to say that, and he said that Jacob Zuma should have been tried together with Schabir Shaik, and that this is way too little, way too late.
Is that a smart strategy to take, to say he should have been convicted?
His reason is that, the evidence that was led during Schabir Shaik's trial was led, and it was led in Jacob Zuma's absence, so he did not have the opportunity to cross-examine the witnesses who were testifying and who were implicating him in this corruption case. But, it certainly is an interesting application that has been brought after all of the interlocutory applications. We all know about the DA having approached the court to ensure the spy tape saga being brought to light, and eventually, after numerous appeals and High Court applications, the NPA has decided to charge him. And, of course, the NPA can only charge a person, be it an ex-president or Joe Soap on the street, if there is a reasonable foreseeability of a successful prosecution.
Yep.
And that is exactly what Jacob Zuma's defense team is saying now, is that these
isn't.
charges are trumped up, that the NPA has made the wrong decision to prosecute him, and that they need the court to intervene and to make a decision on this and to stop this matter in its tracks immediately.
All right, Ulrich, let me just go to David Lewis now. He's on Skype from Corruption Watch. David, just remind us again, this case has been going on for so long now. Remind us why this case is important for the political fraternity, for South Africa as a whole.
Well, it's important for a whole variety of reasons. I mean, not least of all that it's a case rooted in the arms deal that we still have not gotten closure from. And, this is a step in that direction. Here was though he wasn't the president at the time, he was an influential political figure who is alleged to have influenced the course of contracting in the arms deal, and nobody but Schabir Shaik has been brought to justice over the arms deal. And so I think it's important from that perspective. I think it's also important because it does demonstrate that though the wheels of justice may grind slowly, particularly where politically powerful people are concerned, eventually they will grind, and they have ground, and it's now time for Jacob Zuma to face his day in court, which he's been asking for ever since I can remember, almost, it feels like. And this is his opportunity, one that he seems intent upon denying himself, and has seemed intent upon denying himself for the last 10 years.
Now, David,
so it's important for a whole variety of reasons. As I say, it was an iconic instance of corruption. I mean, something that a lot of people refer to as the episode around which democratic South Africa lost its innocence. And as I say, it does demonstrate that no matter how politically powerful you are or were, the law will get you in the end, and that's a very important lesson to send.
Now, David, his counsel in court today, when talking about the NPA, says, and I quote, "Violations of the Constitution in pursuit of even the ugliest criminal we hate cannot be condoned," basically saying the NPA violated the Constitution.
Well, you know, I'm not a criminal law expert or even a constitutional law expert. I mean, I don't see, though, that even if you conclude that Luka and Leonard McCarthy, conspired to set the hearing or the trial or the charge in a manner that suited theirs or somebody else's political interests, that may be the case, and it may well be reprehensible. We don't want any political decision or consideration to affect decisions of the National Prosecuting Authority. In this instance, I don't see how this impacts upon the fundamental question in this trial, and that is, did he accept the bribe for influencing the outcome in favor of the company who is his co-accused in this case? That's really all that is at issue here. There's no suggestion that evidence was gathered unlawfully or that there was any, what I would imagine to be a fatal flaw to a fair hearing and a fair prosecution. And so, yes, I think, and I hope that the court concludes that that this trial should go ahead.
All right, David, let me come back to Ulrich. I just want to stay on that particular matter of the NPA, because to a large extent today, it felt like the NPA was actually on trial today, when you follow the proceedings. And they also said, well, his advocate said the NPA was taking instructions from political parties to time the actions to suit political players as well. And can you also tell me how significant would the conversations or the spy tapes be? How will they influence the outcome?
Well, the reason why it felt to you, and I'm sure to many people, as if the NPA was on trial is because the NPA is what we refer to as dominus litis. They decide whether to prosecute a person or not, no one else. And remember that in terms of our separation of powers doctrine, the NPA is completely objective, separate, and independent from the judiciary, as well as from the South African police. So only the NPA can decide whether to prosecute a person or not. They have made that decision. They have decided to prosecute Jacob Zuma. His defense is now saying that that is the wrong decision. Now, the only way that you can prove that that is a wrong decision is by then bringing this application to the High Court, introducing evidence to the High Court to show and to try and substantiate your application that it is the wrong decision to prosecute. And that is what they did with the spy tapes. Numerous conversations in the so-called spy tapes were quoted in court today, and it was done so by the defense team in order to try and illustrate, in what a Harry casual way they were discussing the prosecution of Zuma, how they were referring to High Court judges and appeal court judges as jokers, and really not giving it the necessary gravity and gravitas that they should have. And I think quite a good strategy, to be honest, and to show that, listen here, this decision to prosecute Jacob Zuma, there has been numerous influences over many years that has influenced us. But again, they're going to have to bring a very strong application, in my opinion, to try and convince the court to stay this prosecution.
Ulrich Roux, thank you so much, legal expert, and also we were talking to David Lewis from Corruption Watch, joining us on Skype. Thank you so much, gentlemen, for joining me in studio tonight.